The managing director of Redmax SDN BHD company called the director of finance Abdul Rahman bin Motahir to his office to sign documents.
Rahman, can you come to my office now? Hi boss, what can I do for you? Sign the document. What's this? Just sign. Okay, as you wish. Zero boss. Zero.
Company Act 64, company contrasts, while a contract may be made by a company in writing under its common seal, be on behalf of a company by a person acting under its authority, express or implied, or C on behalf of a company orally by any person acting under its authority, express or implied, to any formalities required by law in the case of a contract made by an individual shall apply, unless the context otherwise requires, to a contract made by or on behalf of a company. Company Act 71, rights and powers attached to shares, while a share in a company, other than preference shares, confers on the holder the right to attend, participate, and speak at a meeting, b the right to vote on a show of hands on any resolution of the company, c the right to one vote for each share on a poll on any resolution of the company, d the right to an equal share in the distribution of the surplus assets of the company, or e the right to an equal share in dividends authorized by the board, to notwithstanding paragraph 1e, the right to dividends as specified therein may be negated, altered or added to by the constitution of the company or in accordance with the terms on which the share is issued. Data Mohammed through KPMG as an appointed auditor discovered creation of fictitious documents, invoices, payment vouchers, financial reports, etc. to release plaintiffs' monies and self-interest such as a false profit report, 11 Malaysian ringgits, 991,892, actual loss report, 55 Malaysian ringgits, 889,650.
Why there's a lot of money out from our company without my knowledge?
Rahman signed that. You told me to sign it.
Company Act 192, liability of members. One member shall not be liable for an obligation of a company by reason only of being a member of the company. To the liability of a member of a company is limited to a. In the case of a company limited by shares, any amount unpaid on a share held by the member. B. In the case of a company limited by guarantee, any amount which the member has undertaken to contribute to the company in the event of it being wound up. C. Any liability expressly provided for in the constitution of the company, and D. Any liability as provided for under this Act. Company Act 198, persons disqualified from being a director, while a person shall not hold office as a director of a company or whether directly or indirectly be concerned with or takes part in the management of a company, if the person A. is an undischarged bankrupt, B. has been convicted of an offense relating to the promotion, formation or management of a corporation, C. has been convicted of an offense involving bribery, fraud or dishonesty, D. has been convicted of an offense under sections 213, 217, 218, 228, and 539, or E. has been disqualified by the court under section 199, to the circumstances referred to in paragraphs 1, B, and D shall be applicable to circumstances in or outside Malaysia. Free notwithstanding subsection 1, a person who has been disqualified under paragraph 1 may be appointed or hold office as a director with the leave of the official receiver, or B. the court provided that a notice of intention to apply for leave has been served on. Dato Mohammed felt deceived by them and was extremely emotionally agitated, so he fired managing director. Abdul Rahman, the director of finance, expected to be dismissed, so he resigned first. Dato Mohammed sued the two of them because of allegation of siphoning of company funds. Zaharin bin H.J. Zakaria presented as the first defendant and Abdul Rahman bin Motahir presented as the second defendant. After being sentenced by the lower court, it was found that the first defendant was responsible for the forgery of fraud documents, while the second defendant was not guilty because he was a subordinate of the first defendant and needed to execute the order of the first defendant. Company Act 206, removal of directors. When a director may be removed before the expiration of the director's period of office as follows. Subject to the Constitution, in the case of a private company, by ordinary resolution, or be in the case of a public company, in accordance with this section, to notwithstanding anything in the Constitution or any agreement between a public company and the director. The company may by ordinary resolution at a meeting remove the director before the expiration of the director's tenure of office. Free special notice is required of a resolution to remove a director under this section or to appoint another person instead of the director at the same meeting, for notwithstanding paragraph 1b. If a director of a public company was appointed to represent the interests of any particular class of shareholders or debenture holders, the resolution to remove under this section shall be treated for the purpose of determining the time at which he or any other director is to retire, as if he had become a director on the day on which the person in whose place he is appointed was last appointed a director. Dato Muhammad was not satisfied about the results. He believed the second defendant was also guilty, so he turned the High Court judge to retrial the case. After careful investigation by the court, the final verdict of HCJ is as follows.
Defendant is found guilty. This is because as the Director of Finance, he needs to service best interests of our company. Allow me to explain further. Second defendant has an obligation to maintain trust to the plaintiff and shareholders. And as an employee, second defendant needs to be loyal to the company. Nevertheless, only lawful and reasonable instructive must be obeyed by the subordinate. It is understood that fraud documents were created, resulting in plaintiff fund being misused. If the second defendant acts with goodwill, the money will not be out from the company. Therefore, with all the proof given, the second defendant was found guilty and breach of duties of fidelity, lawful fraud, breach of fiduciary duties.
Company Act 213. Duties and responsibilities of directors. When a director of a company shall at all times exercise his powers in accordance with this act, for a proper purpose, and in good faith in the best interest of the company. 2. A director of a company shall exercise reasonable care, skill, and diligence with the knowledge, skill, and experience which may reasonably be expected of a director having the same responsibilities, and be any additional knowledge, skill, and experience which the director in fact has. 3. A director who contravenes this section commits an offense and shall, on conviction, be liable to imprisonment for a term not exceeding 5 years or to a fine not exceeding 3 million ringgit or to both. Conclusion. We respect the court's decision empowering Companies Act 1965 as 132, but we hope more legislation act will be used for similar cases in future to set a good precedent. Our suggestion from Companies Act 2016 are Company Act 64, Company Act 71, Company Act 192, Company Act 198, Company Act 206, Company Act 213. We apply principle K-keep, it, as simple, as short for our assignment for a fast and better understanding of the case as an entrepreneur instead of a lawyer.